Definitions of the tort of assault. There have been various definitions proffered for the tort of assault. According to Winfield and Jolovich, assault is defined as an act of the defendant which causes the claimant reasonable apprehension of the Gold L.J. in Collins versus Wilcock 1984. All 374 defines assault as an act which causes another person to apprehend infliction of immediate and unlawful force on his person. Let's look at the ingredients of the tort of assault. 1. It must be direct and intentional. 2. Conduct. 3. Reasonable fear. These elements are mutually exclusive. This means that all the ingredients must be proved before the tort of assault can be established. Let's look at the explanation of the ingredients. 1. It must be direct and intentional. What this means is that in order to establish the tort of assault, it has to be proved that the action of the tortfeasor was directed towards the claimant, and it was intentionally done. A case for assault cannot arise if a gun is pointed at another party instead of the claimant. 2. Conduct. Some conducts can amount to assault if they are coupled with threatening words that creates the atmosphere of assault. In the past, mere threatening words were not regarded as assault as it was followed with no action, conduct. Note that today, due to the advent of advanced technology like telephones, emails, and social network, the issuing of threats via these means have come to be considered as assault. On the contrary, there could be instances where the threatening words, coupled with the action, could have the opposite effect of implying that there would be no assault. In the case of Tuberville versus Savage, 1669 1 Mod Rep at 3, Tuberville put his hand on his sword and said, "If it were not a size time, I would not take such language from you." Savage later sued for assault. The court held that to prove a case for assault, at least one of the following ingredients must be present. 1. An act intending to cause harm to another person. 2. The other person put in apprehension believes that other person can do the damage. Thus, the court held that by Tuberville's action and words, he meant that he would not assault Savage at that point because it was not a size time. 3. Reasonable fear. For there to be an assault, the fear of the victim must be a reasonable one. To measure this, a subjective test is done in order to examine the victim's state of mind at that time. In the case of R versus St. George 1840, 9 CNP 483, the judge said, "It is an assault to point a weapon at a person, though not loaded but so near that if loaded, it might do injury. However, if the victim knew that the gun was unloaded, any fear would be regarded as unreasonable. The threat must be capable of being carried out at the point it is made." Note that if the defendant was prevented from carrying out the threat, it would still be regarded as assault if he was advancing with that intent. This was the decision of the court in the case of Stevens versus Myers _1830 for C&P 349. In this case, the defendant was advancing with a clenched fist towards the claimant, but was prevented from hitting the claimant due to the intervention of third parties. It was held that there was assault. Now moving on to battery. If you have advanced to this point, then well done. Make sure to like, share, subscribe, and leave a comment below. Definition of the tort of battery. According to Salmond and Houston, battery is defined as the application of force to the person of another without lawful justification. Goff L.J. in Collins versus Wilcox states that battery is the actual infliction of unlawful force on another person. Remember that in assault, application of force is unnecessary to prove it, as long as the person was in a reasonable apprehension of infliction of force on him. Assault is complete. Battery, on the other hand, deal with an actual application of force on the claimant without lawful justification. Are you aware that touching would amount to battery if it doesn't fall within the realm of normal touching experienced in conduct of everyday life? Let's look at the ingredients of the tort of battery. 1. Intention. 2. It must be direct. These ingredients are mutually inclusive. 1. Intention. For one to be liable for battery, The touching has to be intentional irrespective of the fact that it was not meant to cause injury. If the touching was not intentional, it would be categorized as negligence. In the case of Meru versus Nyamuro Cieno, 8/1983, the appellant, an infant, sued through his father for battery suffered when the respondent was flogging him with a rope, which hit his right eye, causing him to lose that eye. According to testimony of the appellant and other pupils, the injury suffered was a result of the deliberate act of the respondent. The defense of the respondent was that it was a mistake and he didn't intend to hit the appellant on the eye. The court held that flogging the claimant was intentional irrespective of whether or not harm was intended, and since harm resulted from this, he would be liable. Thus, damages of 30,000 shillings were awarded. Mind you, it should be noted that if the tortfeasor intends to hit someone but he misses and it touches someone else, the principle of transferred malice would be considered in order to place liability on him. In the case of Livingston versus Ministry of Defense 1984, 356 Nika, a soldier in Northern Ireland fired a baton round at a rioter. The round missed the rioter and hit the claimant. The principle of transferred malice was applied and the soldier was held liable. 2. It must be direct. To be liable for battery, the injury must be as a direct result of the intentional act of the tortfeasor. In Scott versus Shepard 1773 W.M. 1892, Shepard threw a lighted squib into the market and it landed on the stall of a gingerbread seller. Willis picked it up and threw it away. It landed on Rial's stall, who picked it up and threw it away. It struck the claimant in the face and blinded him in one eye. The court held that the injury was a result of the action of defendant and he was held liable for battery. In Gibbons versus Pepper 1695 Ill Rame 38, the defendant whipped a horse so that it bolted and ran down the claimant. It was held that the injury suffered by the plaintiff was a direct result of the defendant's action. He was thus held liable for battery. Let's go to possible questions from your lecturers. Can an assault exist even if the other person can defend himself in such situation? Yes, an assault can still exist even if the other person is capable of defending himself. In law, assault is not about whether the victim can successfully resist or defend. What matters is intention or attempt. The defendant intentionally acts in a way that causes the other person to fear immediate and unlawful force. Apprehension of force. The victim reasonably believes they are about to be attacked. The fact that the victim may be strong, armed, or capable of defending himself does not cancel the wrongful act of the assailant. Another one. Can an armed officer assault another armed officer? Yes, an armed police officer can assault another armed officer by pointing a gun at him, even if both are armed and capable of defending themselves. Here's why in law. Assault is about the apprehension of imminent and lawful force, not about whether the victim is helpless. The moment one officer points a gun at another in a threatening way, the other reasonably believes he is in danger of being shot. That is enough to amount to assault. The fact that the second officer has a gun and could defend himself does not erase the wrongful act. The assault already exists once the apprehension of immediate harm is created. If you enjoyed today's session, do well to subscribe for more.